Chapter 20. Mayhem. Section 390. Definition. Mayhem consists in maliciously and willfully causing an injury to some part of a person's body whereby he is rendered less able in fighting to defend himself or annoy his adversary. Hawkins defines it as a hurt of any part of a man's body whereby he is rendered less able, in fighting, either to defend himself or to annoy his adversary. Blackstone defines it as the violently depriving another of the use of such of his members as may render him the less able in fighting, either to defend himself or to annoy his adversary. This definition, however, is faulty, as a person may be guilty of mayhem in causing an injury to himself. Thus, a person who maims himself to avoid impressment as a soldier or sailor, or to render himself more an object of pity for the purpose of obtaining arms, is guilty of the crime. Section 391. Nature of the crime at common law. At the old common law, the part of the body injured, rather than the seriousness of the injury, determined the nature of the offence. The question was, did the injury impair the man's ability to fight or defend himself? For, as said by Lord Coke, the life and members of every subject are under the safeguard and protection of the law to the end that they may serve the king and their country when occasion shall be offered. To cut off, disable or weaken, a man's hand, finger or foot, or to knock out an eye or front tooth, or to castrate him, or break his skull, constituted mayhem at the old common law. But to bite off a man's ear, or nose, was not mayhem, for, as said by Hawkins, they do not weaken, but only disfigure him. It is to be observed, therefore, that, at the old common law, injuries which merely disfigured a person, no matter how seriously, did not constitute mayhem. It is also to be observed that to constitute an act of mayhem the injury inflicted must result in a permanent disability. As said by Blackstone, the party injured must be forever disabled from making so good a defense against future external injuries as he otherwise might have done. Section 392. Early English Statutes. The chief early English statutes on the subject of mayhem, and which form part of our common law, are the following: 5 Hen. 4, ch. 5, 37 Hen. 8, ch. 6, and 22, 23 Charles 2, ch. 1. Section 393. The Coventry Act. The modern English statute. The Act of 22, 23 Charles 2, is commonly known as the Coventry Act. This name was given to it owing to the fact that it was occasioned by an assault on Sir John Coventry in the street, and slitting his nose by persons who lay in wait for him for that purpose, in revenge, as was supposed, for some obnoxious words uttered by him in Parliament, in which he had reflected upon the profligacy of the king. This act provides that if any person or persons shall, on purpose and of malice aforethought, by lying in wait, unlawfully cut out or disable the tongue, put out an eye, slit the nose, cut off a nose or lip, or cut off or disable any limb or member of any subject, with intention in so doing to maim or disfigure him in any of the manners before mentioned, that then the person or persons so offending, their counsellors, aiders, and abettors, knowing of and privy to the offence as aforesaid, shall be declared to be felons, and suffer death as in cases of felony without benefit of clergy. Section 394. American Statutes. In most of the states statutes have been enacted extending the scope of mayhem as it existed at the ancient common law. Many of these statutes are modelled, in a large measure at least, upon the Coventry Act. They provide, very generally, that mayhem shall include disfiguring a person, by putting out his eye, biting off his ear, slitting his nose, 10 etc., as well as to injure him in such a way as to render him less able to fight or defend himself. Breaking the skull is generally considered not mayhem under our statutes. Section 395. Injury to genital organs. Castration constitutes mayhem, even at common law, and it has been held mayhem to commit this offence upon a slave. Malicious injury to the genital organs of a female was not mayhem at the old common law, but in some states it is made mayhem by statute. Section 396. Means used to inflict the injury. Under most statutes the means employed to inflict the injury is immaterial. Thus, it may constitute mayhem to put out another's eye by throwing corrosive acid into it, or to disable another's arm by shooting it, or to bite off another's nose, where the statute makes it mayhem to cut off the nose of another, or to disable another by kicking him. It has been held, however, under an English statute, that biting off the end of a person's nose, or biting off a joint from a person's finger, is not mayhem, that to constitute mayhem the injury must be done by means of an instrument,